Welcome back to the third and the final panel of this conference, which will deal with provisional measures, reflective laws, and enforcement. And we actually have an interdisciplinary panel for a change, consisting not only of lawyers, but also of experts on enforcement of forensic issues. And the chair of our third panel is Antolin Fernandez Antuña, who is a partner at Antuña and Partners. And Antolin has been for many years working for the government of Spain, representing Spain in dozens of investor-state arbitrations, including those related to renewables. So now, Antolin, the panel is in your hands, and we look forward to all presentations.
Thank you very much, Jarek. Thank you for the kind introduction. And many thanks as well for the invitation to be here today. It's my great pleasure and honor. Thank you, to the organizers and the BICL. It's the second time. Last time we addressed cross-examination skills and the like. And today what we are addressing are three crucial issues in investment arbitration. Namely, one, interplay with domestic criminal proceedings. Two, shareholder claims and shareholder reflective losses. And three, enforcement. But before introducing our speakers, please allow me to make very brief comments on these topics. Regarding domestic criminal proceedings, many times the same factual matrix can be analyzed from different legal orders at different legal spheres. Facts that can be related to corruption and criminal proceedings. So it's relevant to understand that interplay between investment arbitration proceedings and potential ongoing or past criminal proceedings. Numerous questions arise related to how arbitral tribunals deal with the different stages of domestic criminal proceedings. For example, could the failure to investigate by domestic authorities have consequences in the international arena? When overlapping with an ongoing domestic criminal proceeding, are tribunals likely to stay arbitral proceedings? Are tribunals likely to request domestic authorities to suspend proceedings? And finally, what can be the effect of the impact of domestic decisions? Second point, regarding reflective losses in ISDS. Under general international law and under domestic law and corporate law, shareholders of a company do not have standing to claim for damages to the company. Shareholders' claims are barred. However, investment tribunals under investment treaties have generally admitted shareholder claims for reflective losses. For the loss of value in reserve derived from damages to the company and its assets. This phenomenon potentially creates a plethora of problematic situations, namely double recovery, prejudice to third parties, i.e. creditors, treaty shopping, multiple and parallel claims, inconsistencies, lack of predictability, lack of judicial economy, etc. Now, in light of all these potential problems, what can be done? And point number three, enforcement issues in complex arbitration proceedings. With regards to enforcement, just let me remind you two key articles of the ICSID Convention. Article 54 states that contracting parties shall enforce awards as if they were a final judgment of a court. However, at the same time, Article 55 prescribes that nothing in Article 54 will derogate the law relating to immunity of the state from execution. Without further ado, let me introduce to you the three speakers of this third panel of today. First, to my left, now Naomi Briarcliff. Naomi is counsel in Allen & Overy and represents clients in international commercial and investor state arbitrations, and has also advised on state-to-state disputes, including before the International Court of Justice and Iran-US Claims Tribunal. Naomi has experience in institutional and ad hoc arbitration proceedings, including arbitrations under the ICC, LCIA, SCC, ICSID, and UNCITRAL rules. Naomi is recommended by Who's Arbitration, Chambers, and Legal 500, and they describe her as, quote unquote, a rising star and future leader with remarkable expertise in public international law. To my right, David Kavanagh, KC, is head of Scadens Europe International Litigation and Arbitration Group. In 2021, David was named an international arbitration MVP by Law 360 following his success in several major trials where he acted as lead counsel. David acts on matters in a vast range of sectors, including telecoms, airlines, satellites, oil and gas, mining, cryptocurrency, and real estate. He has also acted on several major investment treaty disputes for governments and investors. And last but not least, Ian Jones, to my far left, is an associate managing director in the Forensic Investigations and Intelligence Practice based in London. Ian joined as an analyst in Kroll's London office, and between 2012 and 2022, he was part of Kroll's Middle East practice based out of Dubai. He's also worked in Kroll's Latin American practice in Miami and Mexico City. Before joining Kroll, Ian worked in financial services in London. He specializes in complex investigation, and he has conducted numerous internal investigations, multi-jurisdictional and litigation support and assert and due diligence projects for financial institutions, law firms, multinational corporations, regulatory agencies, and authorities. So, without further ado, Naomi, please.
Thank you very much,
The floor is
Anthony.
yours.
Thank you. Thanks for that great introduction. So as Anthony mentioned, I'm going to talk about the interaction between investment treaty arbitration and domestic criminal proceedings. Investment treaty tribunals are increasingly faced with allegations of corruption on the part of investors. In these situations, the existence, or in some cases the non-existence, of domestic criminal proceedings often becomes a key issue in the arbitration, and as Antoline already mentioned, can give rise to complicated issues for tribunals to address. So, for example, a state may argue that an investment has been procured by corrupt criminal activity and therefore doesn't qualify as an investment under the applicable investment treaty. In those circumstances, to what extent is it relevant that a state has or has not sought to prosecute the alleged criminal activity under domestic criminal law? Another question that may arise, and Antoline alluded to this already, is if such a prosecution is ongoing at the same time as an investment treaty arbitration, should an investment treaty proceeding be stayed pending the outcome of the domestic proceedings? Or if a decision has been rendered in the domestic courts in the relevant proceedings, a further question is to what extent should an investment treaty tribunal take account of that decision in making its own determination on the same or a related issue? Another complicated scenario is one in which an investor alleges that domestic criminal proceedings have been commenced against it, its representatives or counsel, in response to an investment treaty arbitration, either to intimidate the investor or to gain access to information which would give the state an unfair advantage in the proceedings. In this scenario, it's common for an investor to request interim relief from a tribunal. For an example, seeking a suspension of the relevant criminal proceedings until the arbitration is concluded. The tribunal then finds itself in the uncomfortable position of having to navigate the contested border between a state's sovereign rights and the tribunal's duty to safeguard an arbitral process. Now, a sovereign state clearly has the right and perhaps even the duty to conduct criminal investigations and prosecutions on its territory. But in agreeing to arbitrate under an investment treaty, a state generally accepts that a tribunal may order measures on a provisional basis, even in a situation which may entail some interference with its sovereign powers and enforcement duties. So where should the balance lie? A similar question also arises when a state's investigation or prosecution of criminal activity is alleged to be the basis for a breach of a treaty. For example, let's take a scenario where an investor alleges that a state has abused its sovereign power to prosecute in order to expropriate an investment. Now, it's generally undisputed that when implementing laws and prosecuting crimes, states may punish investors by arresting them or confiscating their property without compensation. While states are barred from directly or indirectly expropriating property without compensation under international law, they're not barred from confiscating foreign property or fining foreign investors substantially high amounts while executing their police powers. So how does a tribunal determine whether a state's action constitutes a bona fide exercise of police powers or not? Now, there's a lot that could be discussed in relation to all of these topics, but since the title of our panel today was Provisional Measures, Reflective Loss and Enforcement, and David's covering reflective loss and Ian's covering enforcement, I took the cue that I was supposed to cover provisional measures. So that's the element which I'm going to focus on. And as I've already mentioned, the key issue in relation to that topic is where to draw the line between respecting a state's sovereign right to exercise its police powers and its duty to safeguard the arbitral process. While a few tribunals appear potentially to have considered that they do not have the power to interfere with criminal proceedings at all, and I say potentially because it's really not very clear from the decisions at all what the position is, most tribunals accept that they do have this power, and as a result of the state's consent to arbitrate under particular rules, most commonly, of course, the ICSID rules or UNCITRAL rules. Both of those sets of rules provide that a tribunal has the power to order provisional measures to protect the rights of a party. What those rights are is not limited in the rules, but it's generally accepted that a right must bear relation to a specific dispute. Therefore, when considering whether or not to order measures, interim measures in relation to criminal proceedings, the first point of focus for a tribunal is usually to determine to what extent the measures requested relate genuinely to protecting a right that's at issue in the relevant dispute, as opposed to generally preventing or intervening in criminal proceedings in a state which affect an investor or an investment, but don't have any bearing on the arbitration proceedings. Once the relationship between the measure requested and the arbitration is established, the tribunal must then determine whether the circumstances are such as to justify interim relief. And the test that's applied by tribunals to that question is, on its face, no different in the context of measures related to criminal proceedings than it is to measures in any other context. An applicant must generally show that the measures are necessary to protect the right invoked, that they're urgent, and that they're proportional. And as Bickel's survey on interim measures has shown, this is broadly the case no matter what rules govern the arbitral procedure. And that's despite the fact that the ICSID rules and the UNCITRAL rules address the test for, the ICSID rules didn't codify the test for interim measures in very much detail at all until they were reinvented this year. And the test under the latter rules is just framed completely differently. But nevertheless, those are the core points which investment treaty tribunals tend to look at, regardless of the rules under which they're constituted. But while the test for interim measures doesn't tend to check or doesn't change, regardless of the context, how it is applied does tend to change if you're dealing with criminal proceedings. Notably, in every decision that I've reviewed in preparation for today, tribunals start out by stressing that a duty to conduct criminal proceedings is the sovereign right of any state, and ordering measures which impinge on that right should only be undertaken in really exceptional circumstances. Therefore, and whether or not it is justified, and I leave that out there as a question, many tribunals appear to consider that there's a kind of necessity plus threshold that applies to ordering interim relief in the context of criminal proceedings. When then will that test be held to have been met? And the answer to that is it really depends on the circumstances of the case. There aren't many decisions in which provisional measures have been granted in relation to criminal proceedings. And that's probably because of the very high threshold that's applied, because there are a fair number of applications. And the circumstances across those decisions are very different. Nevertheless, there is one scenario in which tribunals always do seem to find egregious enough to award interim measures. And that is where there is evidence of bad faith on the part of the state in conducting the criminal proceedings that impact or are related to the arbitration. So by way of example, that was the position in the case Kiborax versus Bolivia. In that case, the claimants alleged that the proceedings had been commenced in order to intimidate the investors and deny them the status of foreign investors under the BIT. Now, although the tribunal didn't make any express findings as to whether the proceedings were legitimate or not, it's clear from the decision issued by the tribunal that it found Bolivia's conduct troubling, to say the least. For example, it noted that evidence did appear to suggest that the criminal proceedings had been initiated as a result of corporate audit that targeted the claimants, specifically because they had commenced arbitration against the state. And the tribunal also made reference to a government memo in which it had been recommended that Bolivia should try to find flaws in the claimant's mining concessions as a defense strategy in the exit arbitration. So as a result, the tribunal granted the claimant's request for an order to suspend the proceedings. A similar situation arose in Laos Holdings versus Laos, in which the state appears to have admitted during the course of its submissions on provisional measures that it intended to use evidence that it found in the criminal proceedings in the investment treaty arbitration. Somewhat concerned by that, the tribunal declined to order a variation to a previous interim order it had made, which prevented Laos from commencing criminal proceedings against the claimant. Requests for provisional measures have also been dismissed where there's been no evidence of bad faith on the part of an investor. And that was the case in Gavrilovic versus Croatia and Churchill Mining versus Indonesia. I'll make one final point before handing over to David on this topic, and that is that given the high thresholds that tribunals generally apply to applications for provisional measures related to criminal proceedings, evidence is often an issue. And as you can imagine, evidence of witness intimidation or politically motivated prosecution is often quite hard to come by. But without such evidence, tribunals, faced with the high threshold that they need to establish, are placed in quite a difficult position. An interesting solution that has been adopted by some tribunals recently has been to seek assurances from a state that its conduct before national authorities is bona fide. But as I'm sure you can imagine, and I think, that may not offer the comfort that a persecuted investor is really looking for. And that concludes my comments on the topic.
Thank you very much, Naomi. David, please.
In the recent UK Supreme Court case, Marex, Lord Reed, who gave the judgment of the majority in the Supreme Court, described the principle of reflective loss as being, quote, like a ghastly legal Japanese knotweed whose tentacles have spread alarmingly through the law of obligations. And that rather colourful phrase kind of reflected the fact that in English law and in common law systems, the courts have got themselves into rather a tangle and a mess in relation to the contours and the limits of reflective loss. I wanted just to start by just looking at some of those decisions and then trying to contrast that with the position in investment treaty law to see if the position is any clearer. Reflective loss is a principle which says that shareholders should not be able to recover loss arising from harm caused to a subsidiary, where the loss is claimed by reference to the diminution in the value of its shareholding. And in its purest form, the rationale for the rule is that it's a fundamental principle of company law that the correct party to bring such claims should only ever be the company itself, rather than the shareholder. Now, the Supreme Court in Marix took out its secateurs and tried to cut back some of the growth in relation to reflective loss. For example, it decided that the principle had no application when the claim was being brought by creditors rather than shareholders in respect of harm done to a company. And internationally, different jurisdictions have taken different approaches. In Singapore and New Zealand, for example, the courts have adopted a pragmatic approach, which is to focus on safeguarding the relevant relief in order to avoid the problem of double recovery, such that they said the problem can be dealt with if the court giving judgment can make sure there are certain restrictions on how any damages award can be claimed both by a company and by the shareholder. Hong Kong, for example, has adopted a much more unbending approach to the application of the rule. But other very kind of significant jurisdictions, such as India, have no real developed doctrine of reflective loss at all, even though they do have principles which stem out of the English law case of Foss and Harbottle, which talk about who's the proper party to bring a claim where a company has been damaged, for example, by the negligence or breach of duty of its directors. So how's the concept, if at all, been applied in international treaty law? Well, at first glance, one might say that the answer is obvious. The concept, as characterized by the majority in the Supreme Court, as I've described it, has no real place at all, some would say, in investment treaty law. It's routine for investors to bring a claim for a breach of a treaty where the harm has been done to the company, and the basic measure of the claimant's loss is a diminution in the value of the investor's shareholding. And that's because investors' claims are said to arise at a different level, at the international level of a breach of a treaty, which is separate and distinct from the loss which is suffered by, which the company may suffer as a result under the domestic law by actions of the state in country. And so instead, what we find is that the question when states raise these points have been typically framed by states when faced with multiple proceedings as a question of abuse of process. And I'm going to explore how that's been developed in the case law. So it's abuse of process rather than a question of who has proper title to sue for the loss caused by the state's measures. And what are the abuses that states are generally concerned about? Well, most concerns of states arise from being confronted on occasion with multiple arbitrations on essentially the same dispute set of facts brought by a group, an investor group. And that's because it has become standard when structuring investments to have holding companies in a particular structure incorporated in different jurisdictions with different treaties with the host states, all of which protect indirect investment interests within the group structure. So you can bring a claim at various different levels in theory. And we've seen that the measure of the loss is then typically, in a typical investment treaty case, looked at in terms of the diminution, the value of the shareholding in the underlying project company, which is typically assessed on the basis of a DCF type analysis, comparing the value of that company in a harm state versus the non-harm scenario. Now, the issue can also arise where you have treaty provisions that allow a local subsidiary to be considered as a foreign national for the purpose of the treaty-based claim. And that comes typically from the controlled definition of nationality, such as found in Article 25 of the ICSID Convention, as well as certain other treaties. And an example of that is the OIEG case, which concerned a Dutch investor who had a glass production plant in Venezuela, where the subsidiary in Venezuela was entitled to bring a claim under the relevant investment treaty as well as the parent. Now, states tend to identify the following problems with this state of affairs. Firstly, it's said by states and by their counsel that investors get multiple bites at the cherry. And they say that this is a forum shopping which allows investors to game the system so that they can bring claims before multiple tribunals where they only need to win once, but the state must succeed in all of the arbitrations. And states say they are put to unnecessary expense of fighting multiple cases, often against much better funded commercial opponents. There's a fundamental inequality of arms between the parties as a result. Secondly, states point to the risk of conflicting decisions, both on the breach of treaty standards, but also in relation to the question of quantum. I'll wait for the lights to come back on. And so I'll give you a specific example from a case which we were involved in, and that was a satellite case involving a company called Devas, which was in dispute with India. What had happened was that they'd been guaranteed under a contract the use of certain parts of the spectrum in India, and India decided to effectively revoke its license and the ability to operate its satellites. That led to an arbitration that was a ICC arbitration brought by the in-country company called Devas against Antrix, the space agency of India, which resulted in a successful commercial arbitration award, which valued the business on a certain DCF analysis. One award on quantum. Then there was 2 investment treaty claims, because there were 2 groups of investors. Our clients, who are American-backed, Mauritian-based investors, brought a claim. The tribunal in that investment claim had a totally different approach to the amount of quantum and also the percentage of the loss that was said to be flowed from the alleged breaches. And then Deutsche Telekom, the other contracting party in the group, brought a claim under a Singapore seated investment treaty under the German-India bid, and had a totally different basis for valuing the business based on a kind of willing buyer, willing seller model, which didn't rely on DCF at all. Thirdly, there's a risk of double recovery, where you may have awards in favour of the shareholders and the companies. And states will often say that this cannot be properly policed by tribunals in the same way that it sometimes can be by domestic courts in a domestic situation. And one of the reasons is that there's a backstop of the functionality of the tribunal, that the tribunal become functus officio at the end of the process of its final award. And how is it able to police any restrictions which it puts its in the award, recovering the question of double recovery? The concept of abuse of process is linked very closely to the policy considerations, which also underline the concepts of lis alibi pendens and res judicata, which we heard a little bit about this morning. And these are policies which seek to promote finality to litigation and avoiding conflicting decisions. And at the heart of these policies, and this policy system in most jurisdictions, the common thread required is an identity of cause of action and also identity of parties. And this can create problems for states in the application of such principles to competing investment claims, because we often will have different legal entities under different treaties and different causes of actions for breaches of different treaties, even though the underlying facts may be the same. Now, I would suggest that there's no express rule or even a unified position in the investment treaty jurisprudence prohibiting parallel claims in international investment law. The starting point, I would say, is still the decisions in the well-known cases of CME and Lauder versus the Czech Republic, where both tribunals were asked to consider whether parallel claims by an entity and its shareholder, Mr. Lauder, pursued under 2 different investment treaties and before different tribunals constituted an abuse of process. And both tribunals in those cases decided it did not. Now, Lauder's being followed in a series of cases since then. One is Pezel versus Republic of Zimbabwe. One is Flamingo duty-free versus the Republic of Poland. In Pezel, the tribunal cited the following passage from Lauder, where they said there's no abuse of process in the multiplicity of proceedings initiated by Mr. Lauder, the entity's he controls, even assuming that the doctrine of abuse of process could find application here. The arbitral tribunal is the only form of jurisdiction to hear Mr. Lauder's claims based on the treaty. I won't read it on. Now, in response to this line of authority, the cases which are now most often relied upon by states trying to get out of this conundrum of multiplicity of proceedings are the cases of Orascom versus Algeria and also Ampal versus Egypt. I'm going to just briefly talk about those. Now, Orascom was a case where it was a telecoms case where we acted for the plaintiff in the first arbitration, Orascom against Algeria. And what happened was there was then subsequent cases brought by the kind of UBO of Orascom, Mr. Sawiris. And he tried to persuade the second, and these Algeria tried to persuade the second state, sorry, the second tribunal that the claims brought were an abuse of process. And it's true that the tribunal in that case, on an application by Algeria, was persuaded to deny the admissibility of the claims. And it's also true that the tribunal in its reasoning sought to try and move the matter on beyond the authority of Lauder and CME. But as that tribunal in Orascom made clear, the case was decided on its own quite peculiar facts, which were on any view rather extreme. Algeria had been sued by the main Orascom telecoms business, which is the case which Scadden was involved in, and where we acted for the claimant against Manuel Gaillard when he was still at Shearmans. And the case was settled after Mr. Sawiris had sold out his interest to Vimpelcom. Now, he then brought his own claim based upon the treaty rights of another holding company higher up the chain. And this is the claim that was rejected by that tribunal. And then what the tribunal focused on was the fact that the claims were by parties, but they were not in the same corporate group because of the selling out by Mr. Sawiris to Vimpelcom. And they said that this presented a particular risk of double recovery because their recovery could take place in an uncoordinated manner by parties with diverging interests. In those circumstances, the tribunal was concerned that the additional protection it might be able to give in its award would not be effective and would prejudice unduly Algeria. Now, because of the difficulties of maintaining the abuse of authority argumentation, another line of argument developed by states is an argument based on waiver and estoppel. This was developed by Emmanuel Gaillard in an article in 2017, and Emmanuel had been by that stage on the end of two such cases, both for Algeria and Egypt, of multiple proceedings. So he had a particular interest in this subject. And the argument is that by allowing a subsidiary to bring a claim under one treaty, the investor at the top of the investor chain essentially elects to treat the investment as being exclusively governed by the law of the treaty, which he first allows his subsidiary to bring, and is therefore stopped from bringing a second claim. Now, I'm aware of this being argued. We're going to talk about it in one of the Vodafone cases in a second, it being argued, but I'm not aware that the argument's actually found favour on the basis of an estoppel type argument. Looking at this from the investor side of things, just to look at it from that angle for a second. What I would suggest is that the complaints of states are often exaggerated, and that investors in turn and in contrast have legitimate concerns which can justify the commencement of multiple arbitrations in particular cases, particularly in cases where the state is not accepting jurisdiction under the treaty where the primary claim is being brought. And the reality is that sophisticated investors understand that the theory of the multiple bite of the cherry in practice may be illusory. Standards concerning FET are likely to be similar in content in both treaties. And very often the witness evidence will be, if not identical, then very similar. Such that any finding of breach and quantum for one tribunal, if not strictly binding, may be persuasive on the second tribunal. Now, there are always exceptions to this, and each case obviously turns on its facts. But far more often, the concern of an investor is that of the state objecting to jurisdiction on the primary claim. And if I can just give an example of the case of Vodafone versus India, where we acted for Vodafone and faced this exact issue. What happened in that case was that Vodafone brought a treaty on its, had a business in India. The immediate parent was a Dutch incorporated company, brought a claim under the Dutch BIT seeking declaratory relief against the measures that had been imposed by India. India took a point on the Dutch investment treaty that it had a provision which excluded tax claims, and they said that was enough to disable the tribunal from having jurisdiction to hear the Dutch dispute. As a precaution, Vodafone subsequently then started a claim under the UK India BIT, and the UK being the jurisdiction where Vodafone PLC stood at the top of the ownership chain. And Vodafone accepted that if the Dutch tribunal had found against it on the merits, I took jurisdiction and found on the merits, it would abide by that decision. However, it also said that, well, if India is right and the Dutch tribunal has no jurisdiction, then the claim should proceed in front of the UK tribunal and the case heard on the merits. So that essentially Vodafone's position was that it was put in this particular position of having to go to a second arbitration tribunal because of India's stand on the jurisdictional position under the first Dutch treaty. And Vodafone in subsequent proceedings actually agreed to the consolidation of the two claims, an offer that was rejected by India. Now, in the end, the Dutch tribunal, when we had the full merits hearing, decided that it did have jurisdiction and also found on the merits for Vodafone and granted the declaratory relief Vodafone sought, that there had been a breach of the Dutch treaty by India. India has nevertheless sought to challenge that decision in Singapore's the law of the seat of the UNCITRAL arbitration, and so Vodafone has maintained the UK BIT. What was interesting is that India had objected both to the formation of the UK BIT, tried to get the party appointing the tribunal to not to accept effectively the reference by Vodafone. That was rejected. And then it interestingly sought to bring an application to the Dutch tribunal in order to get the Dutch tribunal, as the tribunal first sees, to exercise a discretion or an interim measure right to prevent Vodafone's parent, i.e. the parent of the sub that was the claimant in the Dutch claim, from bringing the UK BIT. And it did so on the basis of abuse of process, and it also argued the election and waiver point. That raised an interesting question as to whether that first tribunal would have any power to prevent the second tribunal from being formed and going ahead, because on the basic analysis, the sub would not have the power to procure its parent to not to proceed with the original, sorry, with the second arbitration. Now, Vodafone's position, what happened in the end was that the matter went effectively has been in the process of being settled by the Indian government and Vodafone. And the challenge to the award in Singapore is going to be hopefully in the next couple of weeks removed, and the parties will proceed with no arbitration in either forum. The position that Vodafone was contending for, based upon this right to have a safety net of jurisdiction, is actually reflected in the actual decision of the Ampal Egypt investment case, which is often relied upon by states in this context, whereby the tribunal in that decision, in that case, held that there was nothing in principle with parties commencing multiple arbitrations in order to guard against this jurisdictional issue. And in Ampal, it only became an issue once one of the parties, or the claimant parties on the claimant group side, had chosen a jurisdiction in which to fight in. And at that stage, Ampal was prepared to make an order restricting the ability to bring claims under other jurisdictions. Just to finish off, so I would say that I think the consensus still, notwithstanding Oroscop, is that it's difficult for states to succeed in bringing these abuse of process claims. And that very often the real issue is a protective issue, and a legitimate protective issue by investors seeking to guard against jurisdictional claims brought by the state. And perhaps in recognition of that, there is a move amongst states when negotiating their treaties to include provisions which allow for the consolidation of investment claims all brought under the same treaty. And a good example of that is Article 14 of the new India model BIT, which provides exactly for that.
Thank you very much. Thank you very much, David. And now we move to Ian.
Thank you.
And enforcement, please.
Yeah, so I'm going to talk about the use of investigators and investigations, both in terms of formal enforcement process, identifying and attaching assets, but also using investigations and investigative capability to help with informal settlements. You actually don't have to go that far. In recent years, obviously, we've had wide-ranging experience, both in terms of identifying assets at a sovereign level, but also commercial assets owned by state-owned enterprises. And like everyone, I suppose, there's, given the current political and macro environment, particularly in developing markets, there is some logic to the belief that the number of disputes may increase at a sovereign level, and the prospects of resolution become more difficult, particularly as many countries suffer increased indebtedness and domestic political pressure post-pandemic. I don't think that pattern is necessarily universal. I think obviously resource-rich countries, particularly oil-rich countries in the Gulf, oil price $130 a barrel, at the moment around $90 a barrel. You're still seeing the payment cycles to a number of contract suppliers actually speed up, which is relatively reassuring. A second factor to consider, I think, when thinking about whether there may be greater number of sovereign disputes is political regime change. Venezuela was in the 2000s is an obvious example of that under Hugo Chavez, an expropriation of assets in the Orinoco oil belt led to big arbitration claims by Exxon and ConocoPhillips. You're seeing a second wave of left-wing governments in Latin America, starting in Mexico in 2018, or the extent to which López Obrador administration's that left-wing is debatable, but certainly in Peru and Colombia and possibly Brazil when the elections finish. I think that there's an understanding that some of those governments are taking a more practical approach to foreign investors and foreign investments. The final point to consider in terms of the difficulty in affecting resolution is sanctions regime over the last 12 months, particularly against Afghanistan and Russia, and the difficulties in terms of attaching assets against an enforcement award, and the requirement for things like off-act licenses if you wanted to monetize those assets in some form of settlement. We're currently working on a case at the moment that isn't actually an arbitration, but a legal dispute, and it's a relatively small matter, but there's an international company that was engaged with an Afghan counterparty on a supply contract during the sort of NATO-led occupation in the 2000s to 2010s. And they're deeply concerned that even though this company is active as a capacity to pay, whether they can actually accept those funds, because the company is now actively engaged in Afghanistan and particularly has contracts with people in the Taliban and the Taliban regime who could be sanctioned in the future. And so, they could be susceptible to some form of sanctions if they were to accept that money. In terms of asset tracing identification, sovereign assets, obviously there's the obvious distinction between the challenges posed by sovereign immunity. So that's typically property for diplomatic missions, central bank accounts. So the identification of those assets is essentially futile because you wouldn't be able to attach them against an award. So when you're using investigators into corporate sovereign disputes, the clear issue is, firstly, can you identify non-immune assets? And secondly, where are those assets located? Are they located in jurisdictions where enforcement is easier and more accessible? The sort of classic examples of non-immune assets are state-owned enterprises. And really the critical element there is to show that it's an alter ego of the state, to show those state-owned enterprises, if you want to attach them to a sovereign award, were acting under the economic control of the state. There are various ways to do that. An obvious way is to see if there are government officials on the board of directors of that state-owned company, but also more nuanced aspects that we've been engaged on is to look at the level of economic control. So, for example, does a ministry approve the contracts that state-owned entity awards to various counterparties? Do they approve the payment cycles on various variation orders or payments under the terms of that contract? And the value of state-owned enterprises, they typically have subsidiaries and assets in jurisdictions that are favorable for enforcement. Again, Venezuela is a very good example of this. So PDVSA, state-owned oil company, I think in 2019, its oil trading arm in the US, Citgo, was seized by ConocoPhillips and attached against its arbitration award. If you have state-owned banks, for example, they will often have offices overseas and property that they will also own, and overseas bank accounts as well. And finally, shipping and transportation companies, state-owned shipping companies obviously have ships and vessels moving around the world, and airlines, state-owned airlines, obviously planes that can be seized and attached. One asset that is of greater value really than the planes are the parking slots at airports. So if you have a parking slot at Heathrow Airport, that is of much greater value than the plane, which is often always moving around and hard to attach an order against. One example of that is the 30-year arbitration, I think, Kuwait Airways against the Iraqi state. Iraq Airways, I think, mistakenly been very good at avoiding enforcement of that award, and then mistakenly in 2010, I think, sent a plane to Heathrow, at which point Kuwait Airways got all its lawyers prepared to have an attachment order against that, and then I think the plane turned around quickly before they could do anything about it. Other, sort of, I suppose, not so obvious assets would be things like concession awards that states give to international mining companies. They will typically, the money that's paid by the mining companies for that license will typically go into an overseas account owned by the ministry, or you can try and intercept the receivable just prior to that payment being made by the international company. I think a lot of investigation companies advertise the ability to attach export of goods as part of an asset identification process. And it's quite accessible in terms of looking at databases to find bills of lading for large shipments of various commodities that are moving around the world. I would caution that most of those commodities are operating on what's called a free on board basis, which means by the time they leave the country that you're looking to attach an order against, they then actually come under the ownership of the person that's buying those assets. So it's very difficult to intercept them on a legal basis. In terms of investigative methodology, anyone that's used investigative for, obviously in asset identification exercises, it's really a combination of public record work, and depending on the jurisdiction, there can be a huge abundance of that information in somewhere like the US, or if you're looking at emerging markets in places like the Middle East or Africa, you're looking at very limited amounts of information. So most investigators will combine that with talking to people. I think the good thing about sovereign asset tracing is there's lots of noise in the market about the assets that a country can own, either reported publicly or your ability to speak to people. So there's lots of information that you can get. There was a Latin American country that we were working to enforce an award against that published all its old contracts on the website, the state-owned company, and had all the bank account information there, et cetera, et cetera. And you know, so there is a certain level of complacency amongst many sovereign governments that haven't been through this process before, that they will leave a lot of information lying around. There are also limits to information that can be obtained legally, particularly with bank account information. But I think the logic of doing an asset tracing exercise is to, if you can get reasonable admissible intelligence that of an institution that where a state may hold an account, then post-award you can apply for things like Norwich pharmaceutical orders to try and get disclosure on those accounts and how much is in them. The second area I'd like to talk about is more gathering information for more informal enforcement strategies. So particularly trying to understand the negotiating position of a government. We worked on a matter recently where a client had a claim against a state-owned company in Iraq, and we gathered some pretty useful information intelligence that under no circumstances does the state-owned company want there to be any negative publicity associated with this process. And actually that they weren't too far apart in terms of the settlement they were willing to accept. So that level of information we're able to obtain and advise our clients on, and also we're able to advise them on the true decision maker in terms of the payment process. So it wasn't necessarily the person who was normally in charge of the state-owned company, it was actually somebody above them in the government, somebody that they'd be better off directly negotiating with. The one thing I would caution against is there have been some publicly reported examples of people trying to accelerate the payment process from state-owned companies by hiring third-party lobbyists. There have been publicly reported examples of that creating clear corruption issues and concerns. Payments go to the wrong person in that state-owned company, and therefore you're exposed to FCPA breaches and anti-corruption breaches as a result of that. I would caution your clients against going down that path. If they were to do that, then there should be some fairly robust due diligence done on the person that they're looking to retain to do that, and to make sure that they're at least sensitized to Western business practice and anti-corruption legislation. The other, I suppose, advantage of obtaining an asset sort of tracing report is it helps your client potentially sell their claim to litigation funders, and it means litigation funders don't have to do that work themselves as part of the due diligence process. So you can sell them to litigation funders and potentially other actors in the secondary market, other investment firms or law firms who are looking to do something on a contingency basis, or maybe have their own fund as well. We've tried in the Middle East actually trying to sell claims to financial institutions with who have a strong secondary market debt practice. So banks in the country where the claim is being made, in the hope that they would buy that because they may have a better insight into how to achieve settlement than a foreign investor would. But that is not something that we've had too much success with. The final point I'd like to make is obviously a lot of sovereign claims now, if you're looking at substantial claims of hundreds of millions, billions of dollars, the reality is a lot of those are never going to be paid because certain governments just won't have the ability to payments. And now I think there are sort of moves in the market to securitize those claims and have them as some form of bond issuance where a portion of them is just paid off over a period of sort of 20, 30 years. That's something we're sort of fairly alive to and looking at to see how we could potentially support that process. Thank you.
Thank you very much, Ian. So I guess now it's time for comments and questions.
One question, but there may be no answer for it. We know how to enforce an investment arbitration award, a commercial arbitration award, but has anyone come across enforcing a human rights judgment? So let's say someone wins at the European Court of Human Rights and then the state doesn't want to pay. So an exotic question, but curious whether anyone had any experience with enforcing not really traditional arbitration awards.
No, I haven't, but I'm quite keen to.
Yeah, actually, I'd like to ask you to explain a little bit about the whole sanctions issues. So if you encounter an issue where, for example, economic sanctions are applicable, does that change your strategy? And more importantly, does that might that change the award creditors' approach to the whole issue?
Yeah, so I think if I can take the advice of other people on the panel, I think if you, for example, had an order against a Russian state-owned company at the moment, like Gazprom, and those assets were, and some of its physical assets overseas were on the OFAC list, to actually seize those assets, let's say shares in a subsidiary, I think you would have to have a license from OFAC to do that. So that would create a separate legal process, which can be quite lengthy. It can take months and be costs associated with that. I mean, I don't think there have been many arbitration wars against Iran recently, but for example, Iran owns, from the days of the Shah in the 70s, huge amounts of property in Midtown Manhattan, which presumably you would have to have an OFAC license if you were ever to seize those and get awarded against them. So yeah, it does create a complication for that. But I don't, the extent to which it's impossible, I don't think it's impossible, but it would create another legal, an extended legal process to do that with a good sanctions lawyer.
Just to follow up on the sanctions question, have you had any experience with the sanctions related to the Russia-Ukraine, the Russian invasion of Ukraine? Did you have to drop some of your clients, or were there any practical issues related to that?
Well, we closed our office in Moscow, and yeah, I mean, a bunch of associated issues with that. I'm sure.
And it's primarily because of the EU sanctions or UK sanctions, or it was more a policy decision taken?
It was a policy decision, a reputational decision, I think, which I think a lot of people do as well.
Thank you very much. I really enjoyed the panel. I have a question for David Kavanagh. You mentioned the satellite case with India, and I was wondering whether you think that since in that case, and you also mentioned an ICC case and SIAC case, do you think that when we're dealing with complex issues like satellite productions and telecommunications, is it relevant to have the issue solved in an only institution with maybe some set of rules, like for instance, the PCA rules dealing with outer space issues? Do you think that that could be a way of solving this problem? Thank you.
In that case, the issue wasn't really to do with the technicalities of the satellite. I mean, they actually never launched the satellite. That was one of the issues, because they kept delaying the launch of the satellite, because that would trigger payments and bring the issue to a head. So it didn't really arise in that particular case. What that case was about was the use of it, the space in the spectrum, the S-band space. The Indian government realized that it was going to be incredibly valuable, especially in relation to what was 4G, now 5G. And so it became a financing issue, because the government was being accused of selling off what they call the valuable spectrum too cheaply to our clients, because once we had effectively a right to squat on the spectrum, it meant that they couldn't go through an auction with the telecoms ministry couldn't go through an auction of that. So it was really a telecoms licensing issue rather than a technical satellite issue in that case.
Hi, I'm Lakshna. Thank you for a very interesting discussion. My question relates to the topic of reflective loss that Mr. Kavanagh covered. I was wondering if there are really situations where the shareholders' loss is completely inseparable from the loss the company is said to have occurred. Because I was thinking about what the dissenting opinion of the Supreme Court was, where they try to draw a distinction between how the company's losses are based on the net position on a given time, but a shareholder's loss is based on the future. So to that extent, I think they said that you should look at it on a case-by-case basis to some extent. But if you think about it, even companies are valued largely on DCF and future profit basis. I was wondering if any of the panelists had a view on that, and whether you think, or if you could give examples of situations where you would think that a shareholder's loss is truly reflective of the company's loss. Thank you.
I think there's certainly examples and cases where the shareholders are going to have a loss which is completely separate from the diminution in the value of the company in terms of its ability to its reputation is affected. But in an investment case, you're looking at the damage done to the particular investment rather than general damage and loss suffered by the company. That's what you're trying to get the tribunal to measure and give you the remedy in respect of. And one of the issues that you have, I think, which is part of, I didn't talk about on my section, is where especially when you have competing shareholders within a business, where there is a complete one-to-one relationship, especially when there's kind of shareholdings up the chain, because the tendency, I think, in the investment jurisprudence is to treat it as a kind of one-to-one relationship. It's like what they call a locked box, where the money, every pound that the company has lost as a result of the action of the state, translates immediately into a pound lost by the shareholder, and that raises, I think, more difficult kind of issues when it comes to valuations. And that's a kind of jurisprudence as well developed in the English courts, but not so much in the jurisprudence on valuations in investment cases.
we're supposed to have closing remarks at 4 p.m. During Shepherd, but he says he's on his way.
Yeah, no, perfect.
I would like to finish
Well,
the last time we tried.
Yeah, for example, for Ian, what would be the value of conducting asset tracing pre-arbitration?
Well, I think first, most of our clients would like to think they have an asset identification process already underway pre-award, because as soon as the award's established, you want to move quickly to prevent dissipation of assets. And secondly, it also gives you a baseline. So if you do it at the sort of early stage of the arbitration process, you don't necessarily need to do the full asset identification exercise, but you have a high level overview of what the major assets are. And then towards the end of the arbitration process, just as you're willing to enforce, you can see whether there's been any dissipation of those assets over time. And also at strategic level, it informs legal strategy in terms of how much something may cost and whether it's feasible or not. If you know at an early stage that there aren't really any assets at a state-owned company, you can't get attribution to bring in the sovereign state into those proceedings. You're just looking at that state-owned entity. You know at an early stage that you kind of have to settle informally because enforcement in terms of identifying assets in countries that you'd be able to do that easily is difficult. Then it affects your strategy in terms of what you need to do and how quickly you need to do it, I think. So I think there are a number of strategic advantages. I think the idea of getting the award and then say waiting 6 weeks or 8 weeks to do a full asset tracing exercise, you're kind of losing too much time, I think.
Is it it's not a legal exercise or is it a legal exercise? I'm thinking, for example, that in some jurisdictions it takes really long time to enforce an award. And do you have more or less understanding of key jurisdictions, how long it may take, and then you inform your counterparts, your lawyers who are engaging you on the likely costs and duration, or you leave it to lawyers, domestic lawyers in that particular jurisdiction?
So we work closely with counsel, so we'd leave it to the lawyers. We would do the asset mapping exercise, and obviously over time as an investigator, you understand the good jurisdictions for enforcement like the UK, really bad jurisdictions for enforcement, basically the whole of the Middle East. So you have some sense to it, but you would discuss that with lawyers at the outset, depending on the nature of the claim and whether that was in a local court, an investment arbitration process, etc. You know, have a feel for what those good jurisdictions are, but we would work with lawyers very closely right from the beginning, and they would advise that. So the beginning of the asset tracing process, you get a high level overview of where the assets are, and then lawyers will say, okay, we'll focus on this in the US and this in the UK, and then that's where you have a really deep understanding of what's happening. And then when you have the award, you attach just in the US and just in the UK. You don't waste your time in other jurisdictions. Although the Kuwait Airlines case, they finally managed to enforce in Jordan 30 years after the arbitration process started, and that's not many people have, understandably, have the legs for that. So,
and are you aware of cases where the right to enforcement has been sold to someone else? Let's say someone says, "Oh, I can't wait for 10 years to get my $10 million. I'm happy to get $5 million now," and someone else deals with it. Or anyone else on the panel knows about this sort of?
I would say well over half of all investment claims are sold into the secondary market. So, and that goes for commercial claims. There's a very sophisticated secondary market, and it's done. It used to be done primarily on a percentage. You would be effectively buying their enforcement skills and their you were saying their database of lawyers and assets of states and state cases. But increasing, and they would charge a percentage fee, 10% or 20% of whatever recovery. But they would, these days it's more of an you see more off balance, kind of like a balance sheet transaction. They will pay 20, 30 cents in the dollar and then give immediate cash flow to the company. Because in relation to a lot of what states don't think, well, why it's an attractive transaction from both parties is that in the majority of these cases, there will be on the investor's balance sheet, the investment will be written down to zero, will already be written off. So anything that they recover is pure profit for the business in that financial year. So it can be a massive uplift, especially for the individuals who are responsible for the transaction. So there's that incentive also to do a balance sheet type transaction, and then they take the risk. And so when states are thinking that, and of course, obviously you're probably out of the country already, because that's probably the last straw that would have required you to bring the investment claim. But of course, then it's for some of these big investor hedge funds or funds to bring those cases. And of course, there's a huge amount of money sloshing around in the market, because historically they've been very low interest rates. And so people have been not being able to get a return by investing in gilts or standardized securities. So there's a huge amount of money from funds funding litigation and asset recovery.
So who would be the buyers?
It's normally post. Most of these practices will be kind of post the award. They won't want to take litigation risk because it's for the obvious reasons, but they will take and price the award and the recovery of the award against the particular state that you're saying.
Although I mean, sorry, my experience is that where you've got sort of repeat claims against certain states, you do have funds looking to collect awards, because that puts them in a more favourable position potentially in relation to enforcement. And so there'll be contact prior to the award being rendered, although my experience is also that these funds don't tend to want to take any of the litigation risks. They want the secure asset once the award has already been rendered.
And these are just financial entities? These are not really law firms or investigative?
Some law firms, they will have a specialized kind of a department, and they will have people who, that's all they do. So they actually, they are Cobra, and they don't really, well, they argue some cases, but they would typically go to a firm like Arthur, they know, or Skadden, who would have done the actual case and say to the client, look, we're completely conflict free when it comes to trying to enforce these assets against financial institutions. We're conflict free, and we've got a dedicated team of 30 people. That's all they do, is seek to enforce these types of awards. And so sometimes those firms on the smaller awards, they might actually take the award themselves into their own name, but more typically they will broker with an investment fund, and they will provide the legal services, and the fund will provide the balance sheet to buy the case, the actual award itself, taken outright assignment of the award.
But what's quite interesting as well in relation to the buyers is that, I mean, you have those firms, but you also, I mean, typically it was kind of litigation funds that were involved in buying these types of assets. But because, you know, as David explained, the economic position has been as it has been, you're starting to see players in the market who wouldn't traditionally invest in litigation as such, or know nothing about it, but are prepared to take on an award because they see it as,
it can be a great investment, because it's
investment.
Yeah, it's a judgment rate 8% compounded. So if we could ever, if Debas could ever, I mean, like the Debas award, that was a 750 million award at the ICC. It's now ballooned to about 1.3 billion, because it's because it attracts compounding interest at the judgment rate. So obviously you've got to find and enforce, but it can, if you've got the assets there, they can become quite remunerative kind of investments. But it's a game where you pick and choose. But often you would get into an auction process. You would get two funds competing, and you would go to blind tenders on or whatever tender arrangement you wanted in order to get the fund.
And also investigators are doing this more, isn't it? Working on full contingency now to identify assets.
Yeah, that's the traditional model, where it's like you would take 20% of whatever you recover off it, whatever the percentage is. But I always say to clients, when if they're on the potentially on the receiving end of a claim, they've got to watch it, because it's very unlikely that they will be in an enforcement scenario with the person that's been litigating against them. And so you may have an unsophisticated counterparty who happens to win the case because they just write on the contract or the law. It doesn't mean that you're going to be facing them on an enforcement scenario. You will have a very sophisticated, you're very likely a very sophisticated operator, ruthless operator, trying to get their margins back on that award.
Is the contingency fee arrangement a common thing for Kroll? And actually for all law firms? I was wondering, there's a bit of discussion on the UNCITRAL Working Group III about whether it's it's ethical, legal, and so on. But at your firms, I mean, big law firms or smaller, do you work on the contingency basis at all? Well, and separately for Kroll, do you have it?
So we consider it, and we have done before. I think the problem with asset tracing contingency is, how do you define success? If you find the asset, then if it's in a bad jurisdiction, you're probably never going to enforce against it. If you find the asset and it's encumbered with a whole bunch of mortgages, and you're behind a queue of creditors, you can't enforce against that as well. So from an investigator's point of view, you have to define success in terms of actually finding an asset versus actually recovering against the asset and making that work. So yes, we do it, but it depends. We don't do it across the board. It depends on the nature of the dispute. What we can do with that. But it's more becoming increasingly common and more the future.
How about law firms just doing client work or in the ISDS area?
It's much more common than it used to be. Obviously, I mean, there was a change in the rules in the UK a few years ago, but I mean, American firms have been able to do it for forever. I mean, the issue sometimes it's really just a question of kind of pricing out the risk. Sometimes it's not in the. I think there's also a tendency, certainly among some kind of American clients, that they have what's called skin in the game. They want the lawyers to be incentivized. What they don't realize is that you just want to win the case, and you, as long as you get paid, I'm going to try just as hard to win a case against Alan Overy or whoever it might be, whether I've got an uplift or whether I'm just being paid my normal rate, because I just want to win the case. And so whether you actually get that additional effort from the lawyers because they're incentivized, even with an uplift, I think is open to question. But sometimes clients almost insist that you want to operate because that's how they're used to doing their particular business. But I've noticed actually in awards that when we've won cases, and you see these days tribunals encourage parties, so they want to be done with the case with a final award, that you will often see them, they want cost submissions for, and they will wrap up the cost submissions in the final award. So they'll go funckless and say goodbye to you. So they'll want to have, and so you will see the other side's their basic kind of costs that they're claiming for. And I think probably in the last 4 significant commercial arbitrations, which I did, one of which was a state related, but commercial, not an investment treaty. The law firms who were serious sized law firms had a very significant contingency arrangement within their cost of it. Like half was on a contingency basis. Which then made you realise they had to, because there's normally a principle, certainly in London arbitration, an indemnity principle that you have to have incurred. You have to set it all out in order to properly recover it through the tribunal. So I think just on the basis of that, I think it's kind of on the up. And in the investment treaty arbitration as well, it's a lot more competitive on the fees. I was having a discussion with one of the people in the room since Acmea. There's been a kind of contraction, obviously, in the number of European investment-related cases. These cases generally, although there's more economic upheaval giving rise to more claims, the actual spread of time it takes to bring these claims to a conclusion has probably gone from, on average, 3-4 years to maybe 6-7 years. And so that makes them slightly less attractive to funders who are funding the actual litigation itself, because you're tying your money up for a considerable period of time. And on the fees have become very competitive because there's a surfeit of people that were doing, the market, probably over half the market was into European investment treaty claims. That's all gone now. And there's no investment court in place. And so essentially all the people that are doing those claims are seeking to do claims outside, either completely outside Europe or European states, or clients going into BRIC countries or other countries. So there's a lot more pressure on fees because of that.
They should be lobbying for an investment court, I guess, all those people.
Well, the investment court will all be about creating barriers to entry, so that you can increase one's remuneration, and then over time the barriers, as has happened in investment treaty case in law generally, the barriers to entry gradually decline as you realise all good competent lawyers can do investment treaty cases. So that's also part of the pricing issue.
Thank you. Any other questions?
I think there was somebody behind me.
I was. Thank you. Thank you, everyone. I'm Ashna from Allen and Overy. I was just on the asset chasing point going to ask, does the diplomatic relations between two countries also affect your decision when you're looking to enforce an award?
I think it's a legal point, really. In terms of not really, no. I mean, I suppose we would identify that all the assets are out there, the full universe of assets, and then if the lawyers felt that was an issue, then fine. But I've never sort of had that experience before. I mean, I suppose the issue of if you have a claim against a state-owned company and then you want to bring in sovereign into that and attribute the assets sovereign to that claim, then that's one issue. I think we've also tried to do that attribution process to move the seat of arbitration from a Middle East country to an investment treaties forum as well, by showing that state-controlled company was controlled by the state and under the effective control. So to move the seat of arbitration somewhere else at a really early stage, we had to do that sort of investigation to do attribution work, and that was actually looking at the client's own data to see how their payments historically been approved. Was it by the Ministry of Oil and not just the own company who signed off on the actual initial contract, etc. So we've done it to. So in the sense, we've done it to sort of move the seat of arbitration, but in terms of actual asset identification, it hasn't affected anything I've done personally. But it's an interesting point.
I think that's probably most likely to come up in the scenario where you've got a state-owned entity as the claimant trying to enforce, because they are connected to a particular state that may have diplomatic relations with the state against which they're trying to enforce. And I haven't seen it at the enforcement stage, but I've been involved in an arbitration for a state-owned entity before against an organisation that was established by 3 other states. And in that case, the state to which the claimant was affiliated stepped in and said, you absolutely cannot pursue this arbitration because it's too diplomatically sensitive. You're going to have to think of something else. But I can't imagine many scenarios where that would be an issue for a wholly private entity, unless it was looking to get particular licenses in its home state, and the respondent state put pressure on the home state, and then the home state fed down and said, well, no, you're not going to get any licenses if you continue to pursue your award.
I mean, it is private. If it's a private company, often they won't even pursue arbitration if they want continuity of business in a certain jurisdiction. So I've seen instances where you have multinational that would just try and settle something rather than going to arbitration because on a particular claim, because it's worried about whether it will win contracts in the future. But that's a pretty commercial decision. Diplomacy in two countries.
Hi. Thanks. Hi, I'm Henry. I come from Hong Kong, and I'm now studying master in Geneva. And regarding that question about diplomatic immunity and enforcement of arbitral award, I think around 10 years ago, there's this huge fuss in Hong Kong about Congo government issuing bond, and then they didn't pay back. And then those bonds eventually got to the hands of some American investment company. They got arbitral awards against Congo governments, and they tried to seize Congo government's ship docked in Hong Kong. And sorry, yeah, you know that case?
It was the Kensington case.
Yeah.
Against cargoes of oil from Congo.
Sorry.
Sorry.
Sorry,
I complete the question.
Sorry. Yeah, and then in that case, because Congo and China got good diplomatic relationship, so Congo claimed state immunity. And I think at the end, I mean, all the parties hired London souls to fly to Hong Kong to fight that case. I think at the end, Congo got its way and claimed state immunity. And so the bond became rubbish paper. I think that's one case I can think of.
I was involved in that case at the original High Court side of it. We went down in flames for the Congolese entity, and it was a fund called Kennington or Kensington, and they had a very elaborate. They bought the claim up, And then they sought to enforce it, and they used Cleary in New York. There's a series of New York decisions which they were successful. And essentially what they were doing was going around, certain states like Congo had like one resource. In that case, it was a major resource was oil and gas cargoes, internationally traded. And they were basically bringing what we used to call garnishee type claims, or against the receivable. Succeeded in New York, but didn't succeed in other jurisdictions like Singapore and Hong Kong. That's going back a bit, that case now, maybe more than 15 years now, but that was a classic case of very aggressive. I think they bought up the debt at about 5 cents in the dollar, and then were making full recovery against almost half of it through the New York action.
If it's 5 cents on the dollar, does it mean the risk of recovery is very low? I mean, the risk of recovery is very high.
Well, the company they bought the thing had it's just a question of experience. Their kind of experience, the people that had the original debt, was that it was just completely hopeless. They'd been litigating the case so we'd actually put them off. We'd run up a series of roadblocks, and then unfortunately we did two for the job, putting the roadblocks off. And they decided to get somebody better at jumping over the roadblocks. And they put their case together in a very much more effective and efficient way. And then they got to, it was an English court judgment. They got to a judgment in the commercial court. So these things can be brought up. And there's some very, if you can hit the right. If you can hit the right kind of source to make recovery, you can make some serious money, which is why some big New York hedge funds are interested in that business.
Yeah, thank you very much. Actually, there were a few relevant studies over there which we did. They're also available in the electronic format. One is on sovereign wealth funds and international arbitration. We'll also deal with enforcement issues. One on provisional measures. One on costs and duration and investment arbitration. So if you can't find a copy for yourself, then there are copies online as well. I think Audley is here. We can conclude, I guess.
No further question. So please join me in thanking again our three speakers. Please.
Thank you very much. You can stay. I think it will be just 10 minutes or so. Wish. So it's my pleasure to invite Audley Shepherd, who is a partner at Clifford Chance and also chairman of the board of London Court of International Arbitration and a member of our advisory board, to deliver closing remarks of our conference. Thank you, Audley.
Thank you, Jarek. The theme of today's conference has been complex arbitration proceedings in ISDS. In my experience, all ISDS proceedings are complex in one way or another. And the fact that this is the 38th in the series organized by the Buckle Investment Treaty Forum indicates that there remain many issues that require informed comment, such as by all the speakers today, and careful consideration by all those involved in ISDS. ISDS remains as complex as it always was, more complex by the plethora of decisions and the changing treaty landscape. But today the focus has really been on the complications and tension caused by the facts and matters giving rise to an ISDS dispute might be being played out in more than one proceedings and more than one forum. As students, we were taught that international law disputes and national law disputes operate on different planes, and each applies a different governing law. Of course, at times, international law is taken into account by domestic courts. In the English courts, we have seen an evolution or a revolution from a time where judges had little interest in international law to the modern era. And I would refer you to a recent article by David Lloyd-Jones in the Cambridge University Press, International Law Before UK Courts, a question of revolution, sorry, a quiet revolution. This has been brought on in part by the effect of human rights, but also perhaps most recently by the court's interest in the act of state doctrine and watering that down. And there's no better place to comment on that than David Lloyd-Jones. And if you've been watching Supreme Court Live, he's been rather busy recently on the present proceedings involving the Scottish referendum or not. And of course, in deciding international law disputes, it may be necessary to understand the domestic law context, both in terms of nationality or capacity and legality. But as we know, compliance with domestic law does not provide a defense to a breach of international law. But I suggest investment protection treaties and ISDS have changed the landscape fundamentally. Disputes can be played out on both planes with potentially quite different outcomes and certainly different reliefs awarded. The same facts and matters, for instance, that could give rise to an administrative law claim before the English courts could give rise to a claim under a BIT. The relief ordered is likely to be quite different, and the greatest disparity would be in monetary damages. In domestic administrative law proceedings, damages are rarely awarded, save if your house is confiscated for a new runway. In ISDS proceedings, as you know, a successful party will generally be awarded damages, and often very substantial damages at that. So it's unsurprising that this disparity between the legal recourse and relief available to investors in domestic courts and that available in ISDS causes states great concern and has driven a desire to reform the ISDS architecture, if not to do away with it altogether. Today, you have heard about the ways in which the same facts and matters might arise on two planes and the tensions that that can cause. The first session this morning focused on the relationship between ISDS and the domestic courts. Which of us in practice hasn't had a client come into us who wants ISDS advice, and we are told that they are 2 years into domestic court proceedings? Irrespective of what the treaty says about exhaustion of local remedies, irrespective of the liberal jurisprudence on fork in the road, and irrespective of the strict rules of triple identity for res judicata, our first reaction is, oh my goodness, I wonder what has been said and argued that might not be very helpful. Or is there a judgment given that will only leave us with denial of justice claims? The second session this morning focused on the relationship between ISDS and other non-domestic proceedings. We know that it has been a cause of frustration that ISDS does not at times appear to be a multidisciplinary field. It has been said by some that it is really commercial arbitration run by commercial arbitrators and commercial lawyers, but with a different governing law. It is as though investment law has nothing to learn from trade law. That may be changing, although I am not so sure. But human rights law is certainly starting to make its mark, whether as part of the corpus of international law that must be taken into account and applied, or expressly in some modern BITs. Then this afternoon, the focus has been on provisional measures, reflective loss and enforcement. And just looking at reflective loss, and as explained by David, I see this as another example of the tension between domestic law and ISDS. As he explained, the rules on reflective loss in English law are very strict, yet ISDS allows any number of shareholders in the chain of ownership or investors with the same investment, same underlying investment or underlying asset to bring claims, as so long as they are a qualifying investor. As some as you know, I have some experience of parallel claims of that sort. Spike Milligan, the English comedian, wrote a book, Hitler and My Part in His Downfall. And I wonder whether at some opportunity I will have the chance to write a book on my part in the downfall of ISDS as a result of the Lauder and CME cases. But those cases take us back to res judicata discussed this morning and Sam's keynote speech. In our domestic courts, judges can manage overlapping and complex disputes by effective case management. That is much harder, as you have heard throughout today's conference, in the parallel, but at times intersecting planes of domestic law and ISDS, or even other proceedings on the international plane and ISDS. But I suggest that this cannot be remedied by strict rules, as much as we lawyers think that that may be possible. I suggest the best way, perhaps the only way, of approaching these problems caused by complex arbitrations and ISDS is by effective case management. Thank you very much.
Thank you very much, Audley. And that concludes our 38th ITF public conference. I would like to thank all the speakers, all those people who come here from far and from not that far, our events team, Bradley, Liam, Carmel, who were helping in the background with everything to go smoothly. And I look forward to seeing you at our future events. The 15th of November will be the next one, but there will be many more to come. Thank you very much and have a nice weekend.